you all for those joining us. We have a wonderful guest speaker today. Can you all type yes in the chat if you're hearing okay, or thumbs up in the in Facebook. Type in where you're joining us from, your location, and we're gonna get started. Any comments, any questions, please type them in the chat. We'll try and go over all your questions today. We have somebody moderating and looking over the questions. So today I would like to introduce our, we have a wonderful guest speaker with us today, real estate lawyer Zamir Alakozi. He started his education at the University of Toronto, finishing with honors in BA Political Science with high distinction. He studied his Doctor of Law at the University of Ottawa in 2014. He has gone on to work at many high-profile law firms. Then in 2019, with all his knowledge and experience, founded the Advent Legal Professional Corporation. So we are in very good hands today. Please welcome Zamir Alakozi.
Thank you, Feras. Thank you for having me. It's a pleasure to be here. And I know there were some questions you sent last night where people, a lot of first-time home buyers, a lot of non-residents interested in learning more about what their legal obligations are. So excited to chat about some of those things.
Exactly. We had some questions pouring in from last night. Everyone looking forward to this meeting. I want to thank you so much for giving your time and joining us here today.
Pleasure.
Trying to give us as much information as possible. Regarding, mostly we're going to talk about the buying process. We all know how buying or selling a house today is a stressful process, and we try to make it as smooth as possible for either a buyer client or a seller client. And the buying process obviously starts with getting our clients pre-approved before starting anything, because we want to know that they are good on financing and we are able to purchase the property within their financial capability, pre-approvals. So once we get them pre-approved, we start the house hunting for them. And then, as you know, we put an offer on the property, which is through an agreement of purchase and sale. And then it's once the deal is firm and accepted by both parties, this is when the closing process starts, depending on how long the time is from getting the deal closed, getting the deal accepted until the closing. So I'll give you Zamir here to talk a little bit about what should if a buyer has purchased a property, an agreement of purchase and sale is firm and binding on both parties, what is the next step for the buyer?
Absolutely. And I'd like to just first say, Feras, you touch on a very good point, especially in the atmosphere we're in right now. People are very excited to buy. I don't give investment advice, but I can tell you it's one of the hottest markets that I've ever seen. But you do want to keep in mind, you need to be qualified by a mortgage broker, by a mortgage lender. You want to speak to someone in that area to make sure you are actually going to be able to finance this purchase. We do have, especially now, a lot of cases where people have decided to move forward with a purchase without doing their due diligence with regards to whether or not they qualify for a mortgage for that amount. And oftentimes, well, not often, but it does happen sometimes where the deal falls through, or they have to obtain a private mortgage or a mortgage with a much higher interest rate than they anticipated because they didn't put that work in. So I'm glad you brought that point up. And so that absolutely, I agree with you, is the first step in any transaction. And I know individuals who work with you, for us, that's something that you always push. You encourage them to first make sure they qualify for that purchase. So after we've gone past that, really what you want to do is get a lawyer involved as soon as possible. Most of the real estate lawyers don't charge an hourly rate unless things get really complicated towards that, if it becomes litigious. Otherwise, for the most part, they don't charge an hourly rate. It's usually a flat rate for the legal fee. So you want to get a lawyer involved as soon as possible. And there's a number of reasons for this. We'll start with the most critical. Most critical is new builds and condominiums, okay? Now, oftentimes when someone is interested in a new build, they go in there, they see they're like, wow, what a good price, maybe I'll add some decor here and there, they add a few things, give the deposit, walk away, and they're told that their home will be built in 2 years. Now, what you need to keep in mind is that agreement that you sign, it's not written in stone. If you take that to a lawyer during the cooling off period, which is just a few days, the lawyer can actually send a letter to the builder asking for amendments, right? What amendments would we ask for? Well, I'll go over the main ones. There's quite a few. Most of them are not save you, a few $100s, but the main ones we want to consider. Number one is the development fee cap, right? So when you have this big condo complex being built in an area, it's obviously going to have an impact on the roads, on the schools, on the resources in the municipality. And there's going to be usually a tax associated with that the municipality charges the builder, which the builder charges you. So that's something that you can cap, right? And I've had experiences where the clients that I've represented, they've paid $1,000 or $2,000 for the development fee tax. And then another client who didn't go to a lawyer, or someone from the same building, but who came to me a year or two after they had signed the papers, ended up paying $20,000 in development fee taxes. So again, paying 10 times more, right? So you want to take it to a lawyer as soon as you can. Your lawyer will review the agreement with you, will tell you what needs to be amended. That's for new builds. For condos, you want to make sure you bring the status certificate. The status certificate gives you an idea of the health of the corporation. It's something your real estate agent will often help you with. And you take that to a lawyer. It gives you an idea about the overall health and liability associated with the condominium. Unlike a home where you have, when you have your home, you have almost unlimited rights. You can do whatever you want in your home. You can play music. If you are a smoker, you can smoke in your home. If you want to build something, in the backyard, usually much less restrictions to be able to do that. With a condo, you can't just go onto your balcony and start doing a barbecue, or sometimes even smoking inside your own unit based with some bylaws. But beyond that, if you've seen the condo, you're like, okay, well, look, I'm not too concerned. Maybe there's a few bylaws here and there. I'll put up with it. I like the place. I want to buy it. You don't know if there's lawsuits against the condo, which will extend to you, right? You don't know if they have sufficient insurance. You don't know if there are special assessments. So special assessments are things like, for example, if the condominium decides they want to renovate the lobby, they want to replace the balconies, they need to do some major renovations, anything like that. Anything like that that the condo undertakes, it's something that passes over to the new owners. So you want to make sure that a lawyer takes a look at that. And then another thing you'll also notice when you're buying, especially a previously used home, is there's certain additional clauses which your agent will add on to the agreement. So for example, you'll have an inspection condition, you'll have visits, you'll have, for example, whether or not the chattels, such as the microwave or stove or things like that are included, whether or not it's going to be in good working order. You want to talk to a lawyer about how you can actually use those to your advantage, right? And I'll just go through one example here, the visits. So oftentimes you'll have 1, 2, or 3 visits to the property. And as someone who's a new buyer, you're very excited. You're like, well, I want to take my family, go see this house, make sure, everybody has the same feeling about it as I do. And that's not what that's for, okay? What that's for is for you to make sure that the agreement is being fulfilled, right? So, for example, let's say when it comes to the chattel, right? This oven, you want to make sure it's in good working order. If you take a look a month before your closing, that's when you use your visit. Well, even if there's some issues, the seller will just tell you, well, yeah, there is some issues. Yeah, the house is a big mess. Yes, there's a hole in the wall. Yes, all of these problems exist, but we have a month until closing. We're going to get this remedied. We're going to get it fixed. That's not always good enough because you need another visit now to come and make sure, and they don't have to give that visit to you. So what I recommend is always try and do those visits as close to the closing date as you can. And yeah, so in short, my advice, is always take your agreement to a lawyer as soon as you can. Once the lawyer has it, I'll quickly go through the process of what happens next. So we receive your agreement, we review with you. Now that you have a good idea of the home, you've seen it, you want to move forward with the purchase, there's a lot of things you cannot see, right? So you cannot see whether there is judgments registered against the property. When someone is sued, the way that judgment is often enforced is it's registered against the property that you own. So that may be the case. Maybe the current owners were sued for $1 million, and now if the lawyer does not do their due diligence, that's something that you would be liable for as a new owner. So the lawyer takes the time, goes through the due diligence, make sure there's no liabilities associated with it. And then we get in touch with your mortgage broker or mortgage agent, find out how much is being advanced. And then it's really just a matter of getting the transaction closed. So we go through the purchase price, there's land transfer tax, there's title insurance, there's legal fees. So we can go more in depth in that if anyone is more interested, but that's a quick summary of the different types of purchases and what you should watch out for.
Great, Zamir, great information. Thank you so much for adding more information to the process. I wanted to, if we could have a yes in the chat, if you are enjoying this, if you have any questions, please type them as well for us. We do have some questions here I want to go over with you, Zamir, and
yes.
You touched on something that's very important. The same thing in the buying process is that the clients, the first thing they have to do before really, starting the home buying is to pick the right agent, just like as picking tying up with the lawyer. They tie up with their real estate agent to help them with the process, of course, and get them pre-approved, and then tie up with the lawyer. And one thing I have to say, Zamir, not because tying up with the right team and having the right people on your team really helps to make the process smoother and makes the closing process also easier. I know I had to contact you on several occasions at 10, 11 a.m. at night, and you always answer the calls and give me the advice for that I can share with my client. And I would like to appreciate, and if anyone that is on this chat that wants, we will share the information of Zamir in case you need to contact him and have other questions answered. I'm sure he will be he will be accessible to you no matter how busy his schedule is. So I'm gonna touch on the next question, which is it says, can a wife and a husband qualify as first-time buyers for two different properties?
Okay, great. So if you don't mind, first, I want to touch on 2 points. I'm going to answer the question about the two properties with the first-time home buyers, but you mentioned something very important, I think, when it comes to working closely with your agent and all of the brokers that are involved and have a stake in this, right? So very important to pick the right agent. And for as you mentioned, you and I have had chats, sometimes late in the evening on a weekend and things like that. It's very, very important, right? You want to be able to have an agent that is accessible, like for us, where if you're having issues, so for, I'll give an instance where, sometimes Feras will call me and the buyers have gone into their last visit. It's on a Saturday. A lot of law firms are closed on Saturday. A lot of agents, they're a little bit busy on Saturday, not as accessible, which of course was not the case with Feras. He was very accessible. And, we found issues with the property. I was notified. I was able to send a letter to the lawyers. And on the day of closing, we were able to hold back money, right? So for example, if I believe in that instance, there was some damage on a wall or something like that. And because it reached me on Saturday, even though the closing, it was on Monday, we were actually able to get everything ready to be able to hold back some money until that was repaired. So touch on a very good point. Always need to pick the right agent. And I think in this case, the right agent is someone with a lot of experience, but also someone who has a team, lawyers, mortgage brokers, whoever it may be, that they're working with, that are not 9-to-5 lawyers, not 9-to-5 brokers, who are there to make sure the transaction goes as smooth as possible. So I just wanted to put that out there for us, because I know there's been a few instances, and appreciate you putting yourself out there for the clients.
Thank you.
So to touch on your next point, when it comes to the first-time homebuyer rebates, it's very, very specific and very restricted on who can qualify, okay? First of all, you have to be over 18, okay? Second of all, you have to be a permanent resident. Third of all, you have never purchased a property anywhere in the world. Now, it's hard to confirm whether you have purchased anywhere in the world, but at the very least, Canada, if you're being audited, that would be looked at very closely. You can only use it once, right? So let's say, for example, you buy a property, the husband buys a property under his name, and then the wife is not on that title at all. She's not a guarantor, nothing. And then they decide, okay, well, look, we want to buy a second property, an investment property. Since my wife didn't use her first-time home buyer rebate on the first property, now she can use it on the second. That is not the case. Once either spouse uses their first-time home buyer rebate, that's it. You're not going to be able to use it again. The only exception to that rule is if your spouse owned the property, okay, and then sold that property before being married to you. So what does that mean? Even if your wife had owned the property beforehand and you never purchased a home, you never bought a home in your life, you never invested in property, nothing like that. But now you married her and she owns a home still, you lose your first-time home buyer rebate as well. So it's very, very restricted. You want to make sure you speak to a lawyer, you understand whether or not you qualify. But to answer that specific question that you asked, can you qualify for it twice? So the husband qualifies separately and the wife qualifies separately? No, that is not possible.
Okay, thank you. Thank you.
Problem.
I have another question here. It's a bit long of a question. I'll try and see if you can get most or understand it. Let's see. It says, so the buyer is outside Canada and has no status in Canada and wants to buy a home for her daughter who is in Canada. At the same time, the daughter is not yet a permanent resident. Her residency is under process. So the PR application time frame shows that they will get the PR shortly. Her daughter will get the PR shortly. So in this situation, when they purchase the property, will they have to pay the speculation tax, the foreign speculation tax? And if so, would they be entitled for a refund? That's the first part of the question.
Okay, great. So yeah, I'll start off by just giving a general understanding for our viewers about the non-resident speculation tax, and then take it from there. So the non-resident speculation tax, it doesn't apply to all purchases. It applies to what they call the greater gold shoe area. So you can look it up online. I can send a link after, but it's only certain areas. So there's Peel, there's Toronto, usually the surrounding GTA, but it doesn't apply everywhere. So that's the first thing you want to keep in mind. Now, the question specifically is saying the mother is abroad or the parent is abroad, the child is here. The child, I'm assuming, is over 18, and she wants to know whether she can buy it for her child or her daughter who is here, who is not a permanent resident yet, but is in the process of becoming a permanent resident. So we touched on a few interesting points here, and we need to be very specific. It's always good to speak to a lawyer to make sure that the answer is specific to the facts of your situation. But to answer based on these specific facts, first of all, if she's a non-resident purchasing for someone here, you're going to have to pay that non-resident speculation tax, because if she's buying it, so if she's going on title. Now, if she's simply just handing over money to her daughter or paying on behalf of her daughter, but the only person that's going to be on title is the daughter, and she's in the process now, what we call a nominee to become a permanent resident. So if she's a nominee to become a permanent resident, as long as she becomes a permanent resident within 4 years of the purchase, she will receive that rebate. Now, she's going to have to qualify for that herself. That's not going to be something the lawyers will help her with. It's going to be something she'd have to go to an accountant and they'll be able to help her. So you would initially pay that 15% speculation tax, but you would apply for a rebate. Now, another important thing you want to keep in mind, because we were just speaking about the first-time home buyer rebate. If you've never purchased a property in your life and you're a non-resident, right? Because you're a non-resident, you also don't qualify for the first-time home buyer rebate. Okay, that's something you'll have to apply for afterwards. Within 18 months, you can apply. So I'm not saying you're not going to get it. As long as you're in the process of becoming a permanent resident, you will get it if it's done within the time frame. But it's something that you have to do on your own. Now, what we do at Adamant Legal is we actually, as long as you're a permanent resident, we provide that rebate to you immediately, right? So if your land transfer tax is $6,000 and you're getting a $4,000 rebate, you're only going to be paying the difference, which is $3,000. That rebate is going to be applied immediately for you. Otherwise, if you're non-resident, then in that case, you will have to apply for that rebate. And then one last point I'll add to that is the people who where there's an exception to the non-resident speculation tax. The first one we just talked about in your example is the nominee, right? Someone who's applied within 4 years, they're becoming a permanent resident. It's just it's a long process, so they don't want to prejudice you because of that. Another thing is a protected person, right? If you're a refugee, you come here because you're fleeing some sort of violence and you've been categorized as a refugee here. You also are an exception to the non-resident speculation tax and don't have to pay it. And then the third is a spouse, right? It's not uncommon, especially in our community where people get married and that person is not necessarily from Canada, maybe the US or somewhere else, and they come here. So that doesn't mean you lose your ability to purchase a home and not have to pay that non-speculation tax. Because your partner is a Canadian citizen or a permanent resident, you don't have to pay that ahead of time, the non-resident speculation tax.
Okay, thank you. Thank you, Zamir. So it's 15% and it's for the non-resident speculation tax. And if they become a permanent resident within 4 years, they get the refund.
Exactly. Yeah. And you just want to make sure you're in the area where it actually applies, because it doesn't apply to every area.
Okay. And the other question we have is, then please don't forget to like us and type yes in the chat if you are enjoying this talk. And so I'll go to the next question. This is from a tenant. Says, I'm a tenant on a 1-year lease that expires in July 2021. We received a letter from the landlord telling us that he wants to sell the property and we should allow buyers to come in and view the property. Are we, so the question, are we obliged to show the property under the COVID-19 restrictions, knowing that I have a medical condition? If the property goes to a new owner, that's the second part of the question, can the new owner take possession before our 1-year lease expires? And are we entitled to any compensation?
Okay, very good questions. I'm going to answer the easiest part. Yes, they can sell their property to anybody that they want. Just because you are a tenant in that home doesn't restrict the owner from being able to sell that property. Now, that of course doesn't mean that your rights will be restricted. Doesn't mean just because they've sold the property, they can suddenly kick you out of the house or evict you. But are you able to restrict them from selling the property? Like maybe you don't like the new landlord, you had a better relationship with the previous one. You have no say in that, unfortunately. As long as the landlord is continuing to honor the agreement with regards to the lease, you have to well, you don't really have nothing really you can do about it. It will move forward. The transaction will move forward. Before we get too deep into this, the one thing I want to add is, again, going back to having a good agent, having a lawyer that you can work with. If you're selling your property and there's tenants in there, right, you need to make sure your agent is aware of that. You need to make sure your lawyer is aware of that when you're reviewing the agreement of purchase and sale with your lawyer. There are certain certain clauses that you need to add in there to protect yourself, right? So the presumption is if you're selling a property, it's going to be passed over to the new owners vacant, right? That there's not going to be tenants in there. Certainly you're not going to be there. You're gonna leave it in a broom swept condition for the new owners, right? If you don't do that, you are at great risk of liability. You're in breach of your agreement, right? So you can lose your deposit. There's a lot of liability that's associated with that. So as a landlord, as someone who owns a home right now, if you're just thinking about selling your home, reach out to Feras, reach out to me, and that's something that we can chat about. Now, with that caveat, I'll go directly and answer your question, Feras. So there's certain requirements. So the landlord has to fulfill their obligations. You can check this out with the landlord tenant board, but there's a 60-day notice that they have to give. When it comes to showings, they have to give you at least a 24-hour notice. There's all of these rules in place. Now, I know a lot of people now they're revisiting a lot of these questions because they're asking, well, look, I don't really understand with all of the new COVID bylaws and COVID restrictions and possibly further restrictions that are to come, what is going to be presiding? Is it going to be the municipal laws, or is it going to be the agreement, what's in the agreement of purchase and sale? And that's something that's still being litigated at the landlord-tenant board. So we don't have anything decisive, but here's the answer to your question. If you are sick and you don't feel like you need to allow any visits to the home, you think you don't need to, even though, let's say, your lease agreement is up, you're like, well, look, I know you gave the 60-day notice, but for whatever reason, I don't think I need to move out. As a tenant, you have the right to refuse, right? And that the laws in this province are very, very pro-tenant. So again, important to have a good agent, have a good lawyer. If they decide that they don't want to allow any visitors to the home, if they decide that they don't want to leave the property upon the sale, all you can do is make an application to the landlord-tenant board, right? And the only way that you can actually have them evicted, the only way that you can actually force them to allow a showing is through a order by the landlord-tenant board, okay? And again, let's say if this is a very passionate tenant and they really are taking a principled stance here, they can continue to keep this going for quite some time. So if the landlord-tenant board decides, for example, in favor of the landlord, well, this can be appealed by the tenant, right? And if the appeal is accepted, it goes to the divisional court, goes to the superior court. As you can imagine, it can continue to escalate and take several months. So if you are in a position where you have tenants and you want to take advantage of this really hard market, you want to reach out to Feras to help sell your home, best thing to do is reach out to us. We can have a conversation about the different ways that you can approach this, right? When it comes to things like this, you don't necessarily have to just read the rules and be like, okay, which one applies to me? Sometimes you can be strategic, right? So a lot of times these days, what's happening is the landlord and tenant work something out and sign a mutual release, right? So the tenant says, well, look, I'll leave, but you have to, give me $5,000. I need to cover my expenses to move. This is not enough notice, whatever the case might be. So you can work it out personally with each other. You don't have to go through the expensive litigation process through the landlord-tenant board. But again, to summarize, the short answer to that question is no, the tenant doesn't have to. They can go to the landlord-tenant board.
Excellent. Thank you so much, Zamir, for this information. There's a follow-up question to the buyer rebate. It says, what if the spouse on the title initially, let's say after 2 years, the spouse is taken off from the title, can the spouse qualify again for the first-time home buyer rebate in her next purchase? Good question, good question. So the short answer is no, right? Once you use the first-time home buyer rebate, you're automatically not going to qualify. Again, talk to a lawyer. If that's your concern, if you just want to take advantage of the first-time home buyer rebate, speak with a lawyer. There's different ways you can approach it, and I'll give you one example. So we had somebody where it was the parents and then the daughter who was untitled, and obviously the parents didn't qualify. They lived in a home, they were buying a new home, so they didn't qualify for the land transfer tax, but they wanted to. This was a Toronto property, so one thing for us, and some of our viewers may also know, is if you're buying a property in Toronto, there's 2 land transfer taxes. It's not just the one, right? So you get a $4,000 rebate for Ontario land transfer tax. You get a $4,475 maximum rebate for the Toronto land transfer tax. If you're buying outside of Toronto, you don't have to worry about that tax. But in any case, in this example, they wanted to still find a way to take advantage. Well, what you can do is if you're, in that case, the daughter was also untitled, the daughter's a first-time home buyer, you can register it so that the daughter is 98 or 99% owner, and then the parents are the remaining owners. So you get 99% of that land transfer tax rebate. So you can structure this different ways to be able to qualify still. But the short answer is if it's just spouses, one of them comes off title, or even if they were never on title, to be frank, you lose that rebate immediately. Gotcha. Okay, excellent. Thank you. And this is again another question. You've mentioned that the legal fees are a flat fee. So what should a buyer expect in terms of, let's say, closing costs with legal fees total included? And what would the legal fees from the closing costs, approximately the legal fees as a flat fee, what should the buyer expect?
It's a great question, and it's one I get a lot, and I always like to distinguish between legal fees and disbursements, right? Those are two different things. So we have the legal fees, which is for the lawyer to represent you for a transaction. It usually starts at about $9.99, goes up to about $1,200, okay? And that's simply you're paying the lawyer to be able to represent you for the purchase, to do all of the searches for you, to do the correspondence with the other side, and everything that's required as part of a transaction to get this property registered in your name. Okay, so again, so that price is depending on the complexity, if it's a purchase, sale, and so on, between $9.99 and $1,200 is the average. When it comes to disbursement, that's a little bit harder to say. We can give an estimate, but it's really hard to say because we're doing searches, right? So if we're doing searches, sometimes we need to do additional searches if we see something suspicious. And depending on additional requirements by the lender, where they may need us to search additional properties that you own or anything like that, it can be more or less, but the average is usually about $300 to $400 for the disbursements, which is the out-of-pocket expenses by the lawyer. That's not really your biggest expense, right? Your biggest expense really is going to be the land transfer tax, right? The land transfer tax, every time you purchase a property in Ontario, you have to pay what they call the land transfer tax. If you like, Feras, I'm happy to talk a little bit more about how that works.
Yeah, actually, there is another question that says, how is land transfer tax calculated?
There you go. So I'll answer that question. So unlike the legal fees, the land transfer tax is not a fixed rate, right? What it is, it's based on increments. So for the first $55,000, it's 0.5%. And then from 55 to 250,000, it's 1% of that. From 250,000 to 400,000, it's 1.5%. 400,000 to 2 million, it's 2%. And then 2 million, plus is 2.5%, right? So your land transfer tax, it really goes in those increments. So the first, again, 55,000, you only pay 0.5, but from the 55 to 250 would be calculated at the 1%. And so on.
That's from the purchase.
For the purchase, that's right. And again, keep in mind if it's in Toronto, it's going to be double. So you pay from 55 to 200,000. So 55 to 0 to 55,000. That's 0.5%. You're paying it twice because you're paying Toronto and Ontario land transfer tax.
Okay. There's another question here. If a protected person is on the title of the property with a non-resident person, do they have to pay the 15% tax?
Yeah. So if a protected person is on title with a non-resident,
yes,
that's the question. Yeah. So even if one of them are a non-resident, you lose you have to pay that non-resident speculation tax. For that matter, let's just say you're a Canadian resident, you're a permanent resident, right? You're just buying it with a friend, and your friend just happens to not be a non-resident, you lose it as well. You have to pay that non-resident tax. So the only exception to that, where the person coming on title with you is not a permanent resident, and you still don't have to pay that tax, is if it's your spouse. Otherwise, you have to pay for it.
Okay, thank you. It is a similar question, but worded differently. I don't know. It's asking, can a resident and a non-resident apply jointly for a mortgage and be assigned both on the title?
Absolutely, absolutely. So if I understand your question correctly, one person is a permanent resident of Canada and the other person is not. They both qualify for a mortgage and they'd like to purchase a property. So there's no problem with that. I mean, that really has very little to do with the lawyer because this is to see if you're qualified for the mortgage. But when it does come to the lawyer, if your friend is a non-resident, you have to keep in mind, unless that person is your spouse, you're going to pay the non-resident tax, which is 15%. And of course, if it's within the greater Gold Tree area we mentioned.
Okay. And the 15% will be like, let's say the two are, let's say 50-50. uh, they'll pay. It's not that they'll pay half of the 15%. They'll pay the.
No, unfortunately not. No.
All right. Thanks, Zamir. And another question here. Uh, 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 let's see what's okay. So, okay. Now, this is after an agreement of purchase and sale is firm and binding, and both buyer and seller are looking forward to the closing, and then one of the parties backs out or decides not to move forward with the closing. Uh, First of all, it says, as can he do that, or can any party do that? If that happens, what are the consequences?
It's a very good question, and we had quite a few of these cases starting off, with all of the hype that went on with COVID a few months ago. And I mean, now obviously people who invested at that time are very happy to invest. They've made a lot of money in most cases. But when COVID was still starting to become, people were becoming more aware of what's happening. A lot of people got cold feet. They came to me, they came to other real estate lawyers, and they were trying to find ways to be able to walk away from the deal. It's not that easy. These agreements of purchase and sale are very, very enforceable unless you have a clause in there that allows you to be able to walk away in cases of emergencies like COVID, for example. You're not simply just going to be able to walk away from that deal because your financing situation has changed, because COVID, you lost your job and you just don't qualify for a mortgage anymore. All of those circumstances, it's not enough to be able to walk away from the deal. What you want to keep in mind is even in cases where there might be technicalities, right? So, for example, you don't meet all of like the technical requirements. Maybe something was like signed a little bit later than it should have been, or it was accepted a little bit later. Things like that. Those are considered by your lawyer, and we did have situations like that where I was able to help clients be able to walk away from deals because it was signed after the irrevocability period. But that's not set in stone, right? You want to make sure that not only you consider the technicalities, but also your conduct, right? So if despite the fact that you may have found a technicality that may allow you to walk away from the deal, a deposit was given, there was correspondence, there was you waived condition, you waived financing condition, you waived inspection condition. Those are usually going to be looked at much more strongly by the courts than a small technicality that you found. So very, very difficult to walk away from these deals. However, I'm going to say this again, if you have specific concerns, maybe COVID's going to get worse, that you want to be able to walk away or anything like that, or you want, for example, let's say you're selling to buy, but you haven't sold your home yet, right? First of all, talk to Feras, I'll give you better advice on that. But if you do, if you have not sold your home yet and you've already put an offer for a purchase and that's becoming firm, you want to make sure you have a clause in there that makes it conditional on the sale, right? So a lot of these situations can be addressed by just having a conversation with your agent, having a conversation with your lawyer, because as long as you have clauses in there that can protect you in those different situations, you're generally good. But as it is, no, very hard to walk away.
Great, thank you so much. Let's see, I'm going through a question here. So what happens if the either party backs out, like right after, whenever an agreement of purchase and sale is signed by both parties and accepted, a deposit must be paid by the buyer. And like the buyers, after, agreeing, they get cold feet, and the next day they don't bring the deposit.
It does happen. It does happen. So I'll tell you legally, okay, and I'll tell you in practice how it generally works. A deposit is different than a down payment, right? When sometimes if you're buying something, you're buying a piece of furniture or something, you give a down payment, and then over the course of some period, you continue to pay the rest of it, and eventually it becomes yours, right? A deposit is different. A deposit is a promise, right? You're saying, look, I like this house. I want to buy this house, but obviously I'm not going to give you $1 million check and buy it. I have to get a mortgage. I have to go to a lawyer. I have to do my due diligence, right? But to show you that I actually do intend to buy this house and you can take it off the market now, I'm going to give you a promise. I'm going to give you a deposit, $50,000 deposit. This is my guarantee to you that I will purchase this home. Now you change your mind, you got cold feet, you lost your job, circumstances have changed, and you can't move forward with the purchase anymore. So that deposit actually is legally, like it's supposed to go back to the sellers. However, if you dispute it, it's not automatically going to go back. It will be litigated, so it will continue to be held in trust. The agent's not going to get paid. The seller's not going to get any of their deposit back. Nothing is going to happen. It will be in trust, and then you get a lawyer and you litigate it, right? But again, I mean, if the circumstance is that you just decided you don't want to move forward with the purchase, all it really means for you is you're just going to spend some money on the lawyer before you get their money, their deposit back to them, right? So you want to make sure if you're moving forward with a purchase, you definitely can in fact move forward with it and can honor and fulfill your obligations. Now that's the legal side. Let's talk about the practical side, okay? Generally speaking, real estate lawyers are less litigious. We're not court lawyers. We don't go in front of a judge and argue, right? That's not really our main area of practice. We are personable. We like to work with people. We like to work with agents, brokers, and other lawyers. And at Adnan Legal, we do have a lot of closings. We have very good relationships with all lawyers that we work with. And that's actually quite helpful, right? We're always going to have situations, and we certainly have situations where we need extension. We can't close on the closing date. Sometimes our clients just can't close on the property. Their situation has changed, especially since COVID has started, right? Especially sometimes with new builds. I mean, if you're buying a new build, you don't know what your financial situation will be in 2 years, right? So if the lawyer has a good relationship with the other side, they're going to be able to leverage that and maybe get you an extension with a fair agreement for that extension, right? If you need to walk away from the deal, that deposit can be negotiated between the two lawyers so that you sign a mutual release and you don't have to worry anymore. So there's different ways to approach it, but a lot of that depends on the agent that you're working with. A lot of that depends on the lawyer that you're working with. But if we're talking strictly legally, legally it's very difficult.
Thank you.
To walk away, yeah.
We're dropping Zamir's contact info in the chat in case you wanna, to reach out later or after this. If you have more or other questions, you want to speak to Zamir direct, we will drop his contact in the chat. And a question here: if someone wants to add, if you want to add your spouse or child to the title after the date of the sale and purchase agreement as a joint tenant or common tenant, do you need to draft a new agreement?
Great. So you brought up a good question there, and I want to just for our viewers, to explain the difference between joint tenant and tenants in common. Okay, so I'm going to explain that first, and then I'll go ahead and answer your question about whether after the purchase is done, you're able to add someone else on title, like your child or so on. So there's two ways that people can be registered on title, okay? One is called tenants in common, and the other is called joint tenants. Very, very important distinguishing factors here, okay? When you have joint tenants, what that means is you're registering with the ability for the surviving spouse or the surviving person on the title to apply for full title, right? So I'll break that down a little bit more simply for you. So let's say a husband and a wife are registered as joint tenants on a property. If they're registered as joint tenants, and let's say they each have a 50-50 stake in the property, once one of the spouses passes away, the surviving spouse can go to a lawyer, spend a few $100s, and apply for what's called a survivorship application, and they actually gain full title to the property, 100%. You don't have to go through any sort of litigious process. It's just a matter of filling that form out and getting it done. The second thing is tenants in common. Tenants in common, we normally recommend, and sorry, by the way, just to add one caveat to that. So I gave the example of spouses because normally if it's your spouse, you're not concerned whether they apply for a full title afterwards. But this can be done with friends, it can be done with children, it can be done with anybody. But that really is what the main point of that is once one person passes away, you can apply for full title to that property. The other part is called tenants in common. So let's go with the same example. Let's say, excuse me, your spouses of one another, and then you are registered as tenants in common. So 50% A, 50% B. When B passes away, because it's not joint tenants, you can't automatically apply to have that 50% go to you and you have full ownership. That's not going to happen. What you have to do is you have to probate it. You go to probate court. On that 50%, you have to pay a tax. So you can look up the rules. I'm not sure what the current tax rate is, but it's usually about 1 or 2% on that 50%. And then you have to get a court order to be able to take on full title. So it's something that's expensive. It's something that you pay additional taxes where in other circumstances it may not be necessary. And the discretion is left to a judge. I mean, there's rules that they have to follow, but ultimately, that discretion is up to a judge. They may have to look at a will. They may have to look at other things. But very important distinguishing factor. You want to talk to your lawyer about whether you want to register joint tenants or tenants in common. Okay, so that's that. To answer the second part of the question, are you able to just add someone on title whenever you like after the closing? The short answer is yes. However, only if there's no mortgage on title. If there's a mortgage, before even coming to a lawyer, you want to speak to your mortgage representative and find out if you can add someone on title there, right? Because that's an underwriting decision. It's a decision that needs to be made by the lender. They may not want that person on title, right? So if your son or daughter who you want to add is bankrupt, they have a terrible credit, they don't pay their bills, there's a lot of liability, maybe they, and obviously not specific to you personally, but just generally, right? They may have committed some sort of misrepresentation to that lender in the past. So there's a lot of things that the lender wants to look at before they allow someone else to be registered on title. So go to your mortgage representative, find out if they will qualify, and as long as they do, you can add them on there. Speak to a lawyer before you do it, because the question is not really how, but why. Why do you want to add this person to title? What are you seeking to do, right? Because there's many ways. Sometimes we think, okay, well, if we pass away, I want my child to be able to have, some sort of stake in this house. So those are conversations we can have, but there's more than one way to be able to do that. And sometimes it may be to their detriment, right? So if, for example, your daughter is a first-time home buyer, if you add her to the policy, she's going to lose that, right? So you want to speak to a lawyer and make sure it actually makes sense to do it in this way for what you're trying to achieve.
Thank you. Okay, just going over again more questions. So does a will take precedence on the relationship on title?
It's a good question, and yes. So the will is very important, but what you want to keep in mind, right? Let's say, for example, there's A and B. Okay, that's registered on title. A is 50% owner, B is 50% owner, and let's say they're tenants in common, right? Remember, tenants in common doesn't have the right to survivorship, meaning if one person passes away, doesn't automatically pass to the other person. So if they're tenants in common, the will can only determine that 50% which that person owns, right? It's only what you own at the time. Even if they're tenants in common, as long as both of them are still alive, it can only determine the stake of ownership that that person has. Also, just because you have a will, it's not like you have a will, you just show it to a lawyer and you're good to go, right? These things need a court order, so you have to go through that process. We don't give tax advice here, but one thing I will tell you is there are some advantages, and speak to your accountant a little bit about this as well, but there are advantages of registering your title as joint tenants, because if that 50% is not being taxed through probate, and that it can automatically pass on to the survivor, there's a lot of tax advantages that you want to talk about with your accountant that you may be able to benefit from.
Thank you, Zamir. Thank you. Just reminding our viewers to please like our page and turn on notifications in Facebook for you to get always notified whenever we have such webinars, hoping to always answer your questions. We'll be having more of these, and we'll also be discussing with a mortgage broker next Saturday. We'll also keep you notified if you have any mortgage questions. We will answer those next week. I also would like to encourage you to subscribe to our YouTube channel, to our like our Facebook page, and if there's any more questions, I think we are getting towards our end of the session. Please throw in if you have a last a few questions. Again, I want to thank you, Zamir, so much for again giving us time and giving us valuable information today. I hope all our viewers has gained from this today, and looking forward to more continue working with you as a team.
Absolutely.
We'll see if there's any more. If not, I guess so. We've put in Zamir's contact on the chat as well. If you want to reach out, the email and phone number is there. And would like to remind also our buyers and buyer clients that we do offer a guarantee on working with us, which is if you don't like the home that you purchased through us in the first 18 months, we will buy it back from you. And also for those looking to buy, we do have exclusive access to exclusive listings. I know with the market being so competitive, we have access to certain properties that you do not find online. Please reach out to us if you'd like to access such exclusive and off-market properties. Again, thank you, Zamir. I guess that's it for today. No more questions. Thanks again, and thank you all for joining, and looking forward to engaging another webinar.
It's been a pleasure. Yeah, absolutely, Frazan. And as you mentioned, I know we've gone over things a little bit more quickly than I like to. So if there's any follow-ups or if people have any questions, certainly happy to entertain that.
Thank you. Thank you.
Great.
Bye.
Okay. Bye now. Thanks, everybody.